Oh, hey everyone. Okay, it's about noon, so we're gonna go ahead and get started here. Thanks for coming. This is a series of uh, webinars we've been putting on about kind of partnerships and closely held businesses. Oops, we got to go back already. This one we're kind of breaking down different concepts here, ownership versus control, and just want to kind of dive in a little bit there and help people think about how to run their company through. Oh shoot, how am I on mute? Hey Jenny, it doesn't. Hey Jenny, it doesn't say I'm on mute. You can't hear? Can you all hear me? Maybe hit the chat button if you can. Oh, all right. It sounds like you can hear me. Sorry, I was being told like you could not hear me. Sorry about that. Okay, let me get back into presenter mode here. My name is Stan Doida. I'm the founder of Doida Crow Legal. Our firm helps entrepreneurs grow, finance, and buy and sell businesses. So we do a lot of anything from startup, helping partnerships get on the right track, getting on the right path, um, raising money, helping you kind of get that seed to growth level capital. Everything from angels, friends, family, venture capital, private equity, and then we take you through the we can take you through the M&A process too on both the buy side and the sell side. I founded my firm 12 years ago and have been sort of growing it ever since. So I too am an entrepreneur and have started something from nothing and grown it, and learned a thing or two along the way that's been valuable to my clients. All right, we're going to dive right in. Again, we're talking about ownership versus control, and just to kind of talk about the very high level, there are three kind of entities that we'll be dealing with in 99% of the cases. It's going to either be a C corporation, an S corporation, and an LLC. And I like to talk to clients about these different entities as, they like a way to build a structure, a way to build something. And so a C corp, there is a pretty robust and thorough statutory framework, only some of which can be kind of deviated from. You can make certain customizations, and you do that through a host of different documents, articles of incorporation, bylaws, shareholder agreements. I refer to a C Corp as like Legos. We can build some pretty cool, intricate structures. Here I've got the Millennium Falcon of Legos here. We can build some pretty cool structures, but anybody who's played with Legos knows that there's some rigidity to how you play with Legos. Everything's got to fit a certain way. The things have got to clip on. Um, and so, you can build some cool things, but you have to do it in very particular ways. An S corporation, which is often, a fantastic tax vehicle for closely held businesses. A lot of the same sort of statutory framework, and then there's an additional layer of tax rules that apply. And one of those is that we can only do so much with the classes of stock and the types of shareholders. They all have to be individuals or certain qualified trusts. I describe S corporations as these kid Duplo blocks. I could build you a tower, I could build you a box, I can build you, that's about it. There's only a few things you can build with Duplo blocks. The LLC is almost entirely determined by contract, and if there's some variations from state to state. Delaware is extremely, contract favorable. In other words, if you wrote it in the contract, the law will adhere to it. There are certain limitations. But really, I describe LLCs as clay. We can make just about anything. Here, comparison to the C Corp, Millennium Falcon, with the rigidity here, we can make, really smooth ends. We can make some rigid details. We can do a lot of different things. And I think the LLC is probably the most flexible vehicle that there is. All right. So, here are the different entities. And each entity has different roles, though they are very similar across these entities. We use different words to describe them. In the LLCs, you might hear people talk about members. Oops. Members are owners of the business. They hold membership interests or units. Um, in a corporation, they're called stockholders or shareholders, and they own shares of the company, and they have, both in both cases, generally speaking, um, they have the rights to get distributions from profits, and then they have the rights to vote on usually extraordinary decisions, things like amending the whole structure, issuing new class of stock, merging with another entity, selling all the assets, those sorts of, extraordinary items. But shareholders aren't generally deciding things on a day-to-day basis. Where do we enter into that lease? Where do we open that new location? Who do we hire for this role? That's usually done at the next two levels, which is, the managers slash board of directors and officers. In an LLC, we usually call them managers, but that's the controlling governing body. These people don't have to be owners necessarily. And in the in the corporation, it's a board of directors. Again, they don't have to be shareholders. In fact, some larger companies have independent board members who really don't have much of a stake in the company. But these people really decide the business plan. They decide the major day-to-day decisions. They also tend to, I guess, purely I like to tell clients to kind of scale their thinking up to a company like the size of, Google or something to that effect. Or Apple, right? Tim Cook is the CEO. He also sits on the board. He's also, a significant shareholder. But the managers, they decide the day-to-day business decisions and the business plan, and then they delegate the execution of that to officers. Now, in closely held businesses, we're wearing all three of these hats, and it may not feel like there is a difference here, but I would encourage anybody who's kind of starting or in that early phase to really start to delineate, because I think, the typical goal for a lot of folks is, at the beginning they're doing all three of these things, and then, maybe they grow the business to where they don't need to execute all of the business plan. Maybe they've gone so far as to, roll out of the C-suite. Like, remember when Bill Gates came out of the CEO role and just went to the board level. And then, eventually you can get off the board and now you're just a shareholder, just collecting sort of checks. So I think in some ways that is kind of the ideal growth path, to just kind of, grow yourself out of these roles and just end up as a shareholder. But these roles and these entities, they all matter for how we think about partnerships and controls. And so we talked about this a little bit. We're wearing all the hats, but we got to start to delineate those roles. Real quick, I want to go over what I think is probably one of the most common fact patterns that comes across my desk, which is two people coming to start a new business, and they're partners, and maybe they're 50-50, but it's invariable that I'll hear somebody say, "Wow, we've really gotten a lot of advice that we have to be 49-51." And I'll dive into that, because what I'll find is that this number ends up being the shareholder number, like what your ownership is, but it might not reflect your agreement on control. And so I've written here what I call the nuclear submarine. If you've ever had a consult with a partnership with me, you've probably heard me talk about this, but The idea comes from there was a movie, Crimson Tide. It was Gene Hackman and Denzel Washington. They're on a nuclear submarine, and I think Denzel is like the Gene Hackman is the captain of the vessel, and Denzel is his first mate, and in order to launch the nuclear missile that they have on the sub, it requires both of them to turn their keys, and that it's far enough apart where neither one of them can do both of them, right? So there's this culminating scene where one of them won't turn the keys, but really uh, what I described this scenario as is a nuclear submarine. It is the sense that you and your partner, if you are in a 50-50 scenario or in an equal control agreement, you both need to turn your keys when you make a decision. And so, a lot of people will come to me and say, well, we gotta figure out what happens if we don't agree. Uh, to which my answer is, generally speaking, it just means that the measure fails. So if partner A says, hey, I really want to hire this new employee to help us with this, and partner B says, no, I don't want to do that. I don't like that person. We don't have money in the budget for it. It's not part of the business, but whatever the reason is, that partner is not turning their key. And so to me, that's not a deadlock. That is, partner A did not get enough votes to approve their measure. So it fails. Real quickly, I'll give you a distinction of where I think a deadlock could exist in a 50-50 scenario. And I always use the same example, but consider two partners, A and B, opening an ice cream store together, like a physical location, and they're selling ice cream, right? And their lease is coming to the end, and the landlord says, hey, I'm going to sell this property. They're going to level it. This building as it sits is not going to exist. So I'm not going to renew your lease. You're going to have to move out. So now partner A and B need to think about what they're going to do. And if partner A says, hey, I like location A, and partner B says, I don't like location A, I like location B, and they can't come to an agreement. Well, here we've got a scenario where if they can't agree, the business actually grinds to a halt. There will not be any more sales of ice cream once this lease is up, and they haven't found a new place to sell it. So that is, in my opinion, a deadlock. And the former situation where you're kind of deciding whether or not to take an action and not having agreement on it is not a deadlock necessarily. So I always try to get partners to really kind of reframe their thinking that, hey, just because you didn't get your way doesn't mean you need to throw a fuss and think about how you're gonna get out of this partnership at this point. You have to be prepared for some disagreements there. So again, we're talking about ownership and control here, and so that was a little precursor on control, but I'm going to go through each of the entities on how we do this. Oops. In a LLC, like I said, this is like clay. This is so easy and malleable. We can do a lot of different things here. And so control, often will be setting up distinctions in decisions that happen at the management level versus the member level. And so, you might say, a typical management decision might be, hey, should we, take on a line of credit or borrow some money to expand or something to that effect? It's very easy. It's easy to bucket these sort of decisions as, well, this is within the management's control. This is within the member's control. There's some of the other kind of control mechanisms to always think about is how, you got this ability to point or vote in a manager. How do you get them out? Do you need to develop, sorry guys, do you need to develop some removal triggers to oust somebody, for example, for cause, if they're not doing their job, they've done something fraudulent, they've done something, intentionally damaging to the company. They've broken the law, things like that. Uh, and so that's control. That's how we would kind of like mess with control in an LLC. On the ownership side, again, really cool, really malleable vehicle. We can, it can be a situation where, two partners are 50-50, one's putting in all services and one's putting in cash. Well, money doesn't necessarily have to come out in that entity as 50-50. We can pay that person back who put in cash first. We can, pay them back 75 cents on the dollar for, 75 cents of every dollar until they're paid back, and then switch to a 50-50. I mean, there's really a lot of different ways to do that. And that's these different ways are called waterfalls, or we call them waterfalls, where it's just like, pools of money and that have to fill up before you hit the next bucket of money. And then, the other thing on the ownership side is, we can change voting rights. We can create non-voting classes. We can create super voting classes. We can create veto rights so that, maybe a particular investor or a particular partner must agree with something in order for the company to take that on, even if they're sort of minority in ownership. So again, lots of cool things we can do in separating those two concepts in an LLC. C Corp, the way we do it, in a control situation, you know, you want to try to determine who's going to be on the board of directors. One way to control that is to create a voting agreement causing shareholders that they must vote certain people on the board of directors. Again, you want to think about some removal triggers. What if this person commits a cause type event? Do we need to get them out? And then, yeah, we would in either the article. It depends on. This is where the corporation can be like Legos. It kind of depends on what the decision is as to where we have to address that. Sometimes it has to be in the articles of incorporation. Sometimes it can be in a separate, like non-public agreement. The articles and certificate of incorporation, which you file with the state, anybody can access it. But we can kind of set some authority levels for the board of directors and some limitations on them through some of those different documents. Ownership's a little bit trickier to deal with in corporations. Again, think Legos. It's just a little bit of the rigidity to it. Um, you've probably heard of common stock. If there's two partners, A and B, and they both hold common stock, generally speaking, when there's a distribution to those like shares, it comes out pro rata per share. We can't delineate, well, partner A put in 50,000 first. Let's get him 50,000 in cash first. Partner B can then follow. We have to do that through preferred stock. And again, that sort of adds a little layer of complexity. So we have to, one of the ways to kind of change up ownership or how ownership works is through preferred stock. And again, with the C Corp, we can create voting, non-voting, super voting type of an arrangement. Again, now going back to the S Corp, the Duplo blocks, sort of limited. I mean, we can have some control of the board and how we appoint the board, how we remove people from the board. The one area where it's tough is ownership, because one of the tax rules that overlays all of this is that you can't have two classes of stock. They do allow us to create voting versus non-voting stock, but you can't create this preferential waterfall of, hey, this class of stock gets paid first, and then this class gets second, and this one gets third. In an S Corp, it all kind of has to come out at the same time, pro rata to the number of shares. So again, just a little limitation um, on what we can do with that entity. So with that, that's really all I wanted to kind of chat about today. And just again, I think the things to take away from this are, when you are in a closely held business, or even if you're a major role in a larger business, ownership and control can be separated and should be thought of as two different concepts. They are related, and sometimes, like, and again, in an S corporation, they can be very closely related, but they can also, for example, in an LLC, they can be totally apart. I have LLCs where there are sort of passive investors who really have no say in anything. And they have managers who aren't big stakeholders in investment in sort of the capital contributions of that company, that run everything and have almost, unilateral authority to make decisions. So it really can be on both extreme ends in the cases. A lot of this comes down to understanding the entity and choosing the correct one, and then understanding how to accomplish these things in these different entities. And again, if I think every lawyer's probably had the horror situation of just, hey, we got this operating agreement from the internet and just signed it. I mean, that is a sort of thoughtless way to address ownership and control. And I assure you, it probably won't, anything sort of off the shelf isn't gonna kind of address your sort of custom agreements with your partners. So, whenever you have a partner, even if it's as small as a tenth of a percent, I think you need to be talking to somebody professionally about it, particularly if it's an LLC. For example, in Colorado's LLC Act says there's a lot of things that say unanimous consent of the members if you don't have an operating agreement. So the last thing you want to do is give somebody with a tenth of a percent a veto vote over critical decisions. So, and then, hopefully you gathered that this is what we do day in, day out. So this is right in the wheelhouse for us. Really enjoy helping partners kind of get up on their feet and educated about how to run their business from a practical perspective, how to get on the same page with a partner before you actually start doing business. I think we've all probably heard the horror stories of partnerships going bad, and I think in many cases that is a function of just not really getting on the same page early. But that is it. If there are any questions, I would love to entertain them. Otherwise, we are going to continue to do this series of webinars. I think our next topics are going to be about M&A, and I think my partner is doing a bunch as well. So hopefully you learned something. And like I said, if we can be of help, happy to help you. And if there's questions, let me know. I'll hang on for a little bit, but otherwise, I really appreciate you all taking the time during your days and listening to me blab about partnerships. All right, seeing none, I'm gonna close down the webinar. Thanks so much.